Okay, I just want to welcome everyone back from their coffee break and give you a minute or two to take your seats before I introduce the Ombudsman for Children, Niall Muldoon. Just for people from outside Ireland, just to let you know, Ireland was the second country in the world to establish an Ombudsman for Children's office, and it's something that we are really proud of, and it has made an enormous difference to children and young people, particularly in relation to addressing the persistent children's rights violation. It's really given huge visibility to children's rights in the Irish context. And our current Ombudsman for Children, Dr. Niall Muldoon, is a psychologist by background, but he's in his second term. And one of the things about Niall is, he's managed to really maintain the independence of the office, but at the same time be really accessible to children and young people and organisations in the community and voluntary sector. He is very plain speaking, and he says lots of things that I couldn't say in my role, but we really appreciate it when the Ombudsman himself is able to call things out. It makes an enormous difference for the work that we do around children's rights. And one of the things he's really focused on in his time in the office is really amplifying the voices of children who are seldom heard, but also dealing with those persistent human rights violations. I know one of the ones that I'm most concerned about as a children's rights campaigner is the treatment of traveller children who are our nomadic population and the kind of accommodation situation that they're exposed to. And Niall has led a number of initiatives, including investigation, looking at that particular area, but he's also done fantastic work in the area of disability, and I know that children and young people really welcome the work that he's done in that space. He's really built people's capacity and recognition and well-being, and really focused on their access to education. So now I'm going to invite you to take the floor and chair the next session.
Thanks very much, Tanya, and thanks very much for the invitation to chair here. It's a lovely event, something that's been very, very powerful learning throughout the day. It's a real great example of the saying, every day is a school day. I've learned so much today, it's been fantastic. Okay, let me just see. What I'm going to do is I'm going to invite the four people involved in the panel today. I'm going to invite them up now if we can. So we're going to ask Judge Colin Daly, Fiona McAuslan, Professor Ksenija Turković, and Catherine Ghent to come to the stage, please, and we'll get ready to hear from each person as we go along. So we've got a 5-minute window for each person to give their opening thoughts. Then we'll settle down into a conversation for about 25 minutes. And then we'll also be opening up as we start now. If you want to take a look at the code, if you can use your phone from that distances, you can go involved in Slido and send in questions that way. And there'll be 15 minutes to use for the questions as well in the Slido. So we'd ask you to, where you can, link in, use the code. It'll be up here as we go through the day, and add your questions, and we can put that to the panel as well as we go through it. So really looking forward to it. Just before I invite Judge Daly to speak, I just want to maybe just flag one element of the work that we've done in relation in feeding into the process of developing a new family law court. We just made, I'm going to highlight two of the points we really wanted to make, and again, I think it fits in here today. We asked for as fundamentals to be recognised within the new National Family Court Justice System. We wanted the system to be specifically child-centred, not system-centred, so that the National Family Justice System needed to be such so that the sensitivity can be focused on anticipating and accommodating diverse and sometimes complex needs and circumstances of children who engage with it. So that, again, you're focusing on the diversity and the ever-changing needs of the child as opposed to fixing a system. Secondly, we wanted that system to be called the service. It should be the family court service for the children and families that they're dealing with, not the family court system. And again, it's that idea that we create a service so that the service is outward looking and public facing. So again, they're just examples of what we put forward into this major complex area. So I'm going to start off, Judge Daly, I'm going to ask you to perhaps maybe give your opening thoughts for the next 5 minutes on the area that we're dealing with, which is the best interest of the child in parental separation and family law. Thank you, Judge.
Good afternoon, everyone, and I'd like to thank the organisers for inviting me to speak at this conference. It's extremely exciting to be here in Farmleigh today on the first day of the new legal year, talking about how we hear the voices of children in court proceedings. So I feel it sets the tone, perhaps, for the legal year ahead. And it's extremely interesting and timely, I think, to talk about how we protect the rights and the best interests of children when their parents are splitting up and they come before the courts for relief. Cognizant of the fact that it's not an entirely domestic audience, what I intend to do is just to briefly describe the work of the Circuit Court and where we come into contact with families who are breaking up. Then to set out how usually as judges we hear the voices of children in the Irish context, and then perhaps to throw open maybe 2 or 3 questions that I think would be really interesting for us to speak to today. So if I take 2019 as perhaps the last typical year, in that year there were over 5,500 applications for divorce and judicial separation before the Irish courts, and there were also a number of applications for the dissolutions of civil partnerships, cohabitation and nullity, but they're much smaller numbers. There were 4,300 orders granted, and the majority of these cases included orders for the custody or for the access by one parent to children. There were also just about 1,500 separate custody or access orders granted that same year. So I think it's fair to say that on an annual basis, the Circuit Court deals with thousands of families who are going through breakdowns, and even more thousands of children who are a vital part of these families. Of the applications that come to court, most of the cases resolve by way of consent of the parties. So they come to court simply to have their divorce granted. They've agreed the terms of their divorce and how the children are going to spend their time with each parent. We don't have exact figures on this, and I hope that we will get better data as the court service goes through a modernisation programme that it's working through at the moment. Most cases then that don't resolve but are called on for hearing actually result in consent orders being made. So the parties enter into discussions on the day of court itself, and I would say between these and the other consent orders that we're probably talking about, somewhere in the region of 75 to 80% of all cases are dealt with on a consent basis. Cases then that go for hearing frequently involve issues regarding the care of children that cannot be resolved by the parents themselves or by the parties themselves, and they require court hearing and court orders. And then of that subset, there's a smaller but a very significant number of cases that can be described as very high conflict cases. High conflict cases, I'm sure I don't have to tell them to you, but they have a significant level of discord between the parties, even on what might appear to be relatively minor issues. There would be high levels of anger and mistrust between the parents. Often the parents seem unable to let go of the spousal relationship, or perhaps one parent might be trying to exert control or to manipulate the other parent or the family. They're characterised by allegation and counter-allegation. They can result in highly legalised interactions or communications between the parents. And custody and access can become a very particular dispute or area of contention. And this puts the children right at the centre of the dispute, and it's extremely distressing for everyone involved, but I would imagine particularly for the children who find themselves in families that are playing out this particular type of conflict. And we often see in these cases that they result in the children opting out of or refusing to maintain a relationship with the non-custodial parent, and there might be many reasons for that. And certainly in these high conflict cases, they significantly add to the length of time that these cases need to get through before the courts. The speakers earlier have set out the statutory and the constitutional and the international law frameworks, so I'm not going to revisit those, but I just reflect on how the voice of the child is heard in Irish cases. And as I mentioned earlier on, I think maybe 75–80% of cases are dealt with by consent, and the voice of the child really in the Irish courts is heard very indirectly. In those consent cases, it will usually be the parents who will bring the views of the child before the court. In the cases where custody or access is in dispute and the case has to go for hearing, then the court can order expert reports which can provide the wishes or views of the children and also give us advice as to what is in the best interest or what is in the welfare interests of the child or the children. So we've got section 32(1)A, welfare, and B, voice, and section 47, social reports. And these are extremely helpful reports to the court. But as far back as 2008, Judge Abbott, in the case of OD versus OD, when he was discussing section 47, social reports, he noted that they can be cumbersome, they can be expensive, they can be time-consuming. And I think those observations apply equally today as they did almost 15 years ago. Well, judges can also meet children directly, and that's where the judge meets the child. This happens in relatively few cases. We have some guidelines which are set down in the case of OD versus OD that I referred to, and which has been more recently referred to by the Court of Appeal earlier this year in the case of DK versus PIK. It sets out certain guidelines for judges, but it's certainly not as comprehensive as the guidelines for judges meeting children who are the subject of family proceedings, which they have in the United Kingdom. And I think what's interesting about those guidelines is that they see those very much as being not the judge's meeting with the child, but rather the child's meeting with the judge for the child to, or the young person, to tell what their position is. So in conclusion then, I think the question that I feel we need to address is, are we giving sufficient effect to the constitutional imperative or the international imperative that the child's views be heard, particularly in the majority of cases that come before the court? In the small minority of cases where the judge may meet a child, how appropriate is it as we're doing it at the moment? What purpose does it serve? And what training should judges perhaps receive with this? And also then, where we have an imperative to take a young person's views into consideration, there is a tension, I think, between the weight that's attached to those views and whether that should, how that should be taken by the court and when it traverses into evidence. So there are some of the issues that I think we might talk about today. Very good.
I can't believe how nervous a psychologist is telling a panel of lawyers to hurry up. So I'm sorry, sorry. Really sorry. I'm going to bring us on now to Fiona McAuslan, who's Director of Family Mediation and Legal Aid Board. And again, just a few minutes to give us your opening thoughts.
Well, I'd be delighted to know that I'm not a solicitor, so you can absolutely tell me to stop. Family mediation in Ireland really started in the middle of the 1980s when the government publicly funded a pilot project, which has become the Family Mediation Service, which is now in the Legal Aid Board. The Legal Aid Board is responsible for our statutory framework. We have 20 centres around Ireland, and we are free and universal. In other words, anybody can attend. We mediate divorces, we call it all issues. We deal with all issues to do with divorce. We work in some of the courts, never together parents. There's a whole plethora of work we do. In terms of children, we both do child-focused mediation, where mediators are talking with parents and bringing the children into the mediation sessions metaphorically. We also do child-inclusive work, where children come to our service and take part in whatever mediation is happening. Now, I could say a lot more about that, but I actually took a bit of a decision about 10 minutes ago that I actually wanted to address the question of conflict within families directly, because I think it is the issue that we've not quite touched on today, yet it runs through everything. So just bear with me if I take this opportunity to say that where conflict escalates in a family, the voice of the child diminishes. We witness this as mediators, where arguments flare, the needs and the wishes of the child is lost. And where conflict is allowed to go unabated, families are fractured. This is what we see as mediators. So if I was to just simply say my one request in terms of looking at reform of any sort, is we take the lesson of here in Ireland and what Europe has done in the last 25 years and beyond, that the peace process, the eye of the peacemaker needs to be brought to the needs of children and to families. So if we're looking at a system, family mediation, courts, ministerial decisions, frontline workers, we actually understand that every single one of us in what we do and say are peacemakers or otherwise in that child's life or in that family's existence. So I would really encourage any professional in any part of the system to take classes in conflict resolution and mediation, learn about how we can be promoters of peace and good negotiation, how we can, instead of standing over the heads of people while asserting rights, we understand how to talk, negotiate and collaborate on the rights and responsibilities in a way that brings people together. That is one of the most important things I would like to say this afternoon. When we look at the system, it's too fractured. It causes friction. It causes difficulty for families. So the conflict that then happens is our responsibility in a way. So I really would encourage all of us to think of the peacemaking as part of the job we do. We have a great privilege as mediators to sit in the peacemaker seat. It's a huge privilege to work with families where they're at their best and worst all at the same time. It is a delight to work with children and find that voice that can help their parents hear. But most important of all, it is not exclusively our role. It's for all of us to share in that responsibility and privilege so that we can actually move our society to understand that that is as much a focus as anything else that we do. So that's what I want to say.
Excellent. Thank you very much, Fiona. I love the concept of you're a peacemaker or otherwise. So let us all reflect on where we are.
It's never stationary.
No.
Never stationary. We're one thing or the other.
And we
Yeah.
I'm sure we move between them as well at times
Yes.
too.
Yes, we do.
Thank you. That's great. I'm going to ask Colin, Professor Ksenija Turković from the Law Department, University of Zagreb. Thank you very much for being with us, Professor.
Yeah. Thank you very much. Well, I was thinking, first of all, thank you for having me here. It's a real pleasure. I was really thinking at the end of the day what to address. So many things have been said, but what I was missing a little bit was that broader perspective, why we are doing all of this. And I think it's very important when you are trying to come up with guidelines, with something new, with that background, why we are doing all of that and what we would like to accomplish with all of that. And the Strasbourg court actually started to deal with that, and it has certain guidelines, guides in this respect. So when we are thinking, what is the court's approach to these specific social and legal needs of children, then if we are looking at the court's case law, we could actually see two concepts that are driving all of that. And one concept is child's inherent dignity. And that we really understand child's inherent dignity equal as inherent dignity of human being, not different from that. And sometimes even today when I was listening, I had the feeling that we are still at a position that we have a system that is focused on children and it's not sufficiently inclusive of children. Because it is not the point, and I heard a couple of times today that actually we decide what is the best interest of the child. We are doing that for the child. the main point of the whole reforming way of thinking about children is that we include children in our decision making. And why we are doing that? Because they have equal worth as anybody else. Child's human dignity is equal as human dignity. And that's, I think, one very, very important thing. When we are talking about child's dignity, then the court, with the child's dignity, very often connects two other notions. And one notion is child's vulnerability. That the child's vulnerability, because child has inherent vulnerability as well, although we can graduate that vulnerability and we have more or less vulnerable children and so on and so forth, but child's vulnerability is there, and the court is taking that into consideration. So when we are talking about the proof, I put that somewhere for me, but even if I don't, it's not so important. But if you are looking at the cases, then you could see that the court, of course, is developing this issue of vulnerability mainly nowadays in the cases that are related to criminal law and abuse of children. But as we have heard from the first speaker, what is important and what child-friendly justice guidelines are demonstrating to us, all of this is connected. Doesn't matter in which area of law or procedure you are starting to develop certain principles. So vulnerability is not vanishing because you are not dealing with abuse that is criminal abuse, no? So this vulnerability is very, very important notion that has to be taken into consideration, and that is connected to the best interest of the child, and I will tell a little bit about that. And then the third point that is very important and that is emphasized already in the CRC and then developed through the comments, and that was overtaken by the court, is that evolving maturity of the child and circumscribed autonomy. This is the word that the court was using in M&M versus Croatia, where the court has emphasized that the child has autonomy that is evolving, autonomy that is circumscribed, but it is growing with the child as the child is growing and has to be taken into consideration. And then the principle of the best interest of the child, and we have that already from the CRC and from the comment number 14, and we should further develop that notion where the best interest of the child is understood as a substantive rule, as a procedural rule, as an interpretive rule. And if you are looking at the older case law, you could see, although they were not telling that when they were writing the comment number 14, actually you can see that this existed already in the case law of the such division existed in the case law of this Strasbourg court, and Strasbourg court is further developing this. And the biggest development that has occurred in the terms of the best interest of the child for the Strasbourg court was in this procedural area, where the best interest of the child is understood as a procedural rule. And the court in a number of cases has developed a number of elements that could be used. And for me, it was very interesting to listen today how the Irish legislator has developed indicators and what kind of indicators were developed. These indicators were already developed in General Comment number 12 by the Committee of the Children, Committee of the Rights of the Children. And they, to the great extent, overlap. And if we are looking at the court's case law, we will see that the court as well has developed indicators and is using and is referring to certain indicators, but in the case law, the court never wanted to say these are the indicators. This is always just by the way of the example, and it's always quite open and for the development. So these are, I will then stop here. So these are like broader principles that we have to look at when we are thinking about this area. And I will stop here.
Thank you. Professor Turković, and now I'm going to call on our solicitor, Ghent, to give us her opening thoughts.
Thank you. And when you're the final speaker in the final panel, definitely everyone has gone through. So maybe just slightly left of centre. How I ended up working, and I work in child protection, private family law, and I also deal with vulnerable adults in a wardship jurisdiction that we have here. But I started off in criminal law, dealing with children who had absolutely no voice, children who were in the care of the state, who had the most traumatic, difficult family circumstances. And one case in particular influenced me way back then, which, and Jeffrey referred to, the constitutional primacy of marriage. At the time, there was a child who was given heroin aged 8 by his family. At the age of 10, he was living on the streets, being prostituted in Dublin. His parents said to the state authorities, no, he's not homeless, he can come back to us at any time. And because they were a married family, he wasn't designated homeless. He went through the criminal justice system, and his first engagement with the care system was at 17, when he was put into a prison, not for any criminal offences, but because that was the only welfare care placement available for him. So I moved from that into child protection, and dealing with representing, I suppose, children through their guardians ad litem in court. And through that, then I've moved into, well, I practice in all of the areas, private family law proceedings as well. And the kind of cases I tend to do there are, as Judge Daly has referred to, the unfortunately high conflict cases where allegations are made, and often counter allegations as well. So I suppose maybe I think about the system in a slightly different way, because I suppose running through my practice has been seeing the catastrophic failures in not listening to the voice of the child, seeing the catastrophic failures in the voice of the child being there but not being communicated, and I suppose trying to see how does that translate across all those different disciplines which are being dealt with by courts, because I think that there's a common thread kind of running through that. And I think if you look at private family law, the children's interests and the issues affecting them are brought to the court by the parents, whether, as Judge Daly indicated, that's by consent, or whether it's to resolve conflictual issues. And there's great resistance, and I noticed what our President of the District Court this morning said when he made care orders, that he might be regarded as the bad guy. And I think the challenge for us as practitioners in the system is to say, if we're looking at children's best interests, if we're looking at their voices, as Alan said this morning, I didn't want to go home, my social worker was saying, go home. The system, you're not the bad guy for making those orders. And interfering with parental rights has to be done within all the caveats that we all know in terms of European law. It has to be done within all the caveats of our Constitution, which is a very strong protection of parents' rights. But private family law proceedings, where there's high conflict and disagreement, also represents an interference with parental rights. And I think, and I haven't decided on this question, but it might be an interesting exercise in thinking about private family law proceedings when we talk about the best interests and interference with parental rights, to which there's huge resistance in public law proceedings. But how does that concept translate into there? Why don't we have it that the child's best interest is paramount, and that means that we then work backwards from that? And the reality is, certainly in adversarial systems, that would have to bring about an entire change in the way in which we deal with all these cases, because it simply couldn't be as adversarial. It would bring about changes, certainly in this jurisdiction, in terms of, and I think that's part of the key question, who brings the voice of the child to the court? You know, here in Ireland, unless you have money to pay for expert reports, your child doesn't get to put their voice before the court. And even if you do have money, your child's voice doesn't necessarily come before the court, because we don't have regulation. There are certain criteria set out of people who can do it, but we don't have regulation. There's no independent oversight. There's no independent evaluation as to how these people are working. And that wouldn't be acceptable if we're to change the whole system, to start thinking of it as radiating from the child and working backwards from there. Children meeting judges, children being represented by lawyers. The longer I'm in this whole area, I realise the less I know and the less equipped I am to talk to children and young people. That's not to say I haven't done it. That's not to say there are times when it's appropriate to do it, there are, but we have to be conscious of our own lack of professional qualification in that. And I think a huge problem is not just accountability of the system, for that has to be there. And how do you evaluate? How do you carry that out in private family law proceedings? How do you evaluate the system? Because everybody goes, and unless you have an exercise, which was done in the previous to Jeffrey's session, which I think is vital to try and understand that, you don't even know what that is. So I suppose for me there's a conceptual idea in private family law that's absent from that at the moment. And I wouldn't be imposing a degree to which it should be, thought of. But I suppose it's that idea as to the visuals of a court in private law proceedings. You have two parents or a parent and guardian on either side of the court. The child is not there. And in making orders, custody and access are hugely difficult. They're particularly difficult when you have people sitting in front of you trying to make eye contact with you, crying, and you don't have the person about whom the orders are being made there in front of you or properly represented, particularly if there's not money to pay for it. So I think that we need to, I suppose, recalibrate, and it's a question rather than an assertion, in terms of that centering the child at the heart of it. And what does that mean? How can we do it? And it's particularly difficult because there are no mathematical formulas if you're dealing with law to do with people. It's tangible law. It's messy law. People are messy. Their lives are messy. And trying to fit a formula to that is difficult. The ECHR procedural approach, I think, is probably the best. As Jeffrey's indicated again, the indications there. So I think that's maybe what, because everybody else has said what I wanted to say earlier. So I suppose I'm just throwing that out there.
Okay, thank you very, very much. Thank you very much. And again, we're going to have about 20 minutes or so now for conversation. I suppose it'll not come as any surprise that I'll be taking more of this sort of honing in maybe on the emotional side of things and on the personal side of the children. And each one of you have touched on the personal impact of the conflict that comes with children. And generally, what you'd look here, the first question would be, where are the gaps? All this sort of, we've highlighted a lot of that stuff today. Maybe I'm going to do again, throw out the best question, I think, is just like you were starting. What is the magical system? If we had resources weren't an issue, people weren't an issue, how could we do it? And again, you've started the ball rolling. I think it started with the child in the centre and build out from there, which is, certainly something I can get behind. Judge Daly, perhaps from your point of view, if you were allowed to design it to make it better for children, how would it look from your point of view, do you think?
Okay, well, it's a very big question. I think it's very interesting having heard the opening remarks of the rest of the panel, and what we've all reflected on is the high emotional content of these cases. And when you're dealing with law and when you're dealing with an adversarial law procedure, we work to put emotion out of the equation. And that's one of the founding stones on which the procedure is built. So, and we see it very frequently in those cases that go on for hearing before the courts, that very frequently there's very few assets. There's one house and there's two children, and the children are young and they're going to have to live somewhere for the rest of their lives. So that house is going to have to be the place where the children live, and then one of the parents is going to live there for most of the time, and then the other parent is going to either see the children there or see them somewhere else. But the parents are hurting because their relationship is broken up, and even though they've been advised by their legal representatives that this is what's likely to happen, they want to have that opportunity to express that hurt. and for somebody to hear it, and then for somebody to make that decision. And very often that's the court. So while we try to take the emotion out of the equation, you can't ignore the fact that this is a very emotional time for parents and for their families. So I think that any system that's going to be better is going to be a system, perhaps like Fiona's system, that addresses the emotions and gives the family, the parents who are grieving the breakdown of an extremely important relationship in their life, and the children who are grieving and dealing with their parents' grief, and also dealing with perhaps the loss of, or the feeling of loss of one or both of their parents. So that's where I would suggest we start looking at it. So.
Okay. Do you want to perhaps follow on there?
Yeah, I'm going to answer this very practically, if I can. If you use a conflict resolution process thinking, the best cases I ever did as a mediator were linked to a judge, like Judge Daly, where the mediator can do their work. The family has good information at the start. There's an assessment. Are they suitable for this process? There is the ability to bring in a professional if required. They have an opportunity to negotiate what they can. We get an opportunity as a mediator to de-escalate the conflict. And the court can either make an order, take the mediation agreement and make an order, or in a case I did a good number of years ago, highly complex and far too long to go into detail, there was, it was my most challenging and most the best, in a sense, case in terms of a system, that this particular childcare piece of work with a whole load of family involved on all sides were in mediation, but the mediation agreement would go to the judge and the judge would make it a court order for 3 months because he could see this will work. And the legal teams argued their cases, but the mediation agreement could actually function. It wasn't torn apart once it came out of the mediation. And I think there's something in that, sticking to the conflict resolution principles and process, that good quality information, good quality engagement for all the people involved in the dispute, access to the courtroom where court orders need to be made, but in a supportive way, rather than a deconstructing way in terms of a resolution, and to absolutely have access to the professional, whether they be for legal services, whether it's child services, whether it's accounts, finance, whatever, that they can inform a negotiating process that is dealing with some of what Judge Daly is talking about in terms of the ebb and flow of the family dynamic.
So it seems like a lot of the emotional work was done outside the courtroom.
Yes.
Some degree of agreement was brought forward to a judge who allowed it to work for 3 months.
Yes, yes. And I think really critically here is that we're talking of big emotions, but actually the really successful pieces of parenting plans is down to those little things. I remember once doing a mediation where it was a Jehovah's Witness, and it wasn't until we sat and looked at the plan on the flip chart that both parents saw that their child was going to be going to services literally 8 times a week. And I could then sit down and say, well, what does that mean for you as a family? Now, that's a very different question to can be asked in a courtroom. But that parenting plan was very, very subtle, very much around the faith of the family, lots of little questions, lots of little things tried. Then it went into the court and could be given some corseting, shall we say. And the family had both developed a capacity to be able to talk about what mattered to them in the parenting plan, but also had some rigour around the parts of the plan that needed to be legalised.
Great, thank you very much. Professor, perhaps have you...
Yeah, well, what we have heard is actually solving the problems between the parents, mediation that is related to the parents and resolving the problems between parents, but actually we are here to talk how we could help children. So I think we should focus and think and try to come with some proposals in this respect. And as often, sometimes I'm thinking, this is not for the law, this is for the psychology. And very often when you get the case and you see what is happening, the law actually cannot do much here. There is something else that should be involved there. So yes, 30, 40 years ago we came with mediation in New Zealand or Australia or wherever, and it has been spread around the world, and it is quite successful for certain types of conflicts. But then we really have to think what would help children, and that we should concentrate. Of course, if the mediation helps, the sooner you resolve the problem between the parents, the sooner the conflict is put down. It's much easier for the child. But really, what works for the child and the type of assistance that has to be given to the child, and then in these terms, the information, the education of children, that is going on in society, that is going on already in school. Actually, nowadays, when we have how many percentages of marriages that are dissolved? Almost 50% now, if we are looking. It is coming from 30 to 50% in Europe, depending upon the society. So this is something that we are encountering on a regular basis. So this is something that should be part of reinforcing children, actually, and how we are reinforcing children and prepare them for something like that. And then when we are looking at the fees, could we as societies, when we are dealing with children, could somehow we free children from the fees? We have heard here, when we are having the expert witnesses, when we are having this or that, there are the fees to be paid. Could we somehow, as a societies, decide that when the children are concerned, fees will not be there? And could we substitute somehow, and really be helpful? Then, for example, when we are looking at the criminal law system, we have all kinds of assistance for victims. And the system that is developed, victims assistance system, especially in, UK, Ireland, I suppose, as well, and Scandinavia, could something like that be developed for family disputes? Could there be something like that, when you are thinking transversely? I don't know. So I'm just, thank you.
Thank you very much, Professor.
Yeah, I suppose just maybe on practical levels, they're totally different kinds of family law. You have the kind where people just fall out of love, and then you have the kind where false allegations are made, you have the kind where true allegations are made. Where the latter arises, certainly in this country, we need to escalate bringing in of the Barnhouse model, so namely a comprehensive model so children aren't over-interviewed, the process is streamlined, and with that we need more judges, we need more courts. I have a case at the moment where there's child protection and Garda involvement. It took over a year to get dates to resume a hearing, and everyone's in a position of suspended animation. That can't happen. There has to be total working together and people knowing the limits and the practicalities of a properly integrated system between criminal law and family law, where those issues arise in there. Because the only difference in private family law, and this is where child protection services in this state certainly step out, is that there's deemed to be one protective parent. So here, if you are a protective parent, which is a really good thing, but your child has made allegations to you, the state protection authorities will generally step back because your children are okay and they have too much to deal with. So we need a more integrated approach, and I think what you're suggesting there about similar to the criminal domestic violence support system, and even in that, if you look at a child who is a victim in the criminal realm from having been hurt by a parent or a guardian or someone close to them, and access is dealt with in our courts. It's a very practical issue. No one would expect a child victim who's before the criminal courts in that capacity to have access with the person who abused them. But delays in our system, lack of knowledge and lack of proper experts and regulation of experts mean that children in our system are having access. And part of it is, as a judge, first of all, you don't know all that's happening because we don't have that proper in-depth way to bring the voice of the child in. And I was struck by something which Prof said earlier. In social work, it's about relationships. What professional in private family law proceedings has that relationship with the child? And who would that be? And that's actually a really difficult question, because more than, as you said in your presentation, it takes time to develop that. And in that time, the child's life's moving on. So what would be unconscionable in the criminal courts happens in the family law courts. And you have it on the other side as well. And delay in the system perpetuates that lack of proper policing, joined up child protection and private law proceedings and the court systems around it all lead to that. So they are the difficulties. We need systemic accountability. We also need accountability for judges. There are some people, and there are lawyers as well, and we are sometimes wildly enthusiastic about going in to take on areas that other people don't want to take on. But sometimes we're just not the most qualified or the most appropriate people to do it. To my mind, we need a rigorous, like a really rigorous appointment process where, in particular, if you want to sit in the family law courts, the child protection courts, you go through some sort of not only system, but evaluation, which would be better for yourself. If you're not the person to sit in those courts, don't sit in them. But there should be some official regulation or delineation of that. So they're kind of practical issues which I think might help.
Okay. It's fascinating to hear the different aspects that are happening here. But again, what we're looking at is if we start from the child outwards and look to create a system that allows them to go through a family separation there's no easy way of doing it, but in the more centred to their needs way of doing it, it changes the way you look at the system. So again, we recognise that all of our court systems are 200-300 years old, based on an English system, based on hierarchical. The wise, the more intelligent, educated person knew what other people were thinking. We need to fundamentally change that and not quite throw it out, but look to bring it about in a new way. So it's that adversarial system. Is that something that professional silos will rally against, perhaps? Is that something that, do we add in a different element to it, or do we change it completely so there's options between adversarial and mediating, conversation, whatever you want to call it, to provide for those children? Is it two parallel systems, two options, or do we change the system completely?
I think it's interesting. There's a Court of Appeal judgment here where they talk about that, is it a totally adversarial system, or is it an issue to be decided, and where does the line go? And the court ultimately said that's not at issue in this case, but it's interesting that it's flagged, and I think that our constitutional referendum certainly has placed that as a bigger question at the heart of it. Like, for example, the judge gave the example of if a judge in private family law proceedings can order a report, is that in and of itself stepping into the not quite adversarial but more inquisitorial system? And it's difficult because at the same time, in child protection proceedings, if you have experts coming in, it's only when you question their reports, and sometimes they fall apart, that actually justice is done, because the proper outcome comes out through the evidence and through the cross-examination. So that's a really, really tricky question, because if you start going into a judicial but quasi-judicial kind of function, and in a sense you're hiving off or farming out to other professionals or other disciplines, the job, as Judge Daly said, that you're then finally coming back to the lack of emotion and dealing in the legal aspects of it, or the decision making. So that is a really tricky line. It's I think on the agenda from that decision, but it hasn't been decided here.
Judge Daly, any thoughts on that?
I think I might have a slightly stronger view than Catherine, perhaps, that the superior courts have told us that family law proceedings in this jurisdiction are inter partes proceedings, so they are by their nature adversarial. No doubt Catherine might argue it before me again and persuade me otherwise. And that is the system that we have. That is the system that the statutes set down, and that our legal system operates. that doesn't prevent us from considering other options. And I think I'll echo Fiona's point earlier that we've seen great successes in cases where they come before the court and then they go through a mediation process and then they come back with a solution, perhaps to all of their issues or perhaps to 80% of their issues. And that can be extremely powerful. So I think there's room certainly for two disciplines to work together. And there's also been some efforts, I think, in the Canadian courts for more round-table court approaches to matters. It's not something I've done a whole lot of research on, but it's certainly, there are perhaps lessons that we can learn from other jurisdictions to take that less formal approach to things and take a more, let's sit around together and try and work through solutions. Okay. Again, this is working mainly between the courts and the parents who are the parties before the court. And I think if we're looking at a more young person-centric or a more child-centric approach, then we also need to look at how do we factor that into the equation. The high conflict cases that Catherine mentions, I think it's endemic upon us to be able to identify those cases at a much earlier stage and to try to manage those cases, to be able to get the expert reports sooner rather than later, to try to prevent I suppose further abuse really occurring during the court proceedings themselves, because they can be extremely traumatic for every member of the family, whether it's the parents or and particularly for the children.
Okay, thank you very much.
Just to add, I mean, one of the things that we've been finding in the last number of years, traditionally, if you go back to the start of family mediation, it was mediation or courts, and if you were in mediation, you had to suspend, et cetera, but really, in the last number of years, what we're finding is that we can work together and take discrete pieces out and involve children where we can. And I think one of the things that we have really not utilised to its fullest is considering how does a family come out the system. So if a court's proceeding has done its course, it's gone its course, and I've done a few cases over the years where at the other end, you're working with the family and maybe some social workers to help the conflict at that point de-escalate and some sort of functionality, for want of a better way of putting it, that going forward the family's not just left coming out of court having gone through this experience. And just to conclude on that, one particular case I do remember was where parents had been in the court for 5 years, and I was going to be meeting their child, and actually they said to me, we haven't talked about our lad for 5 years. They'd been in the court, they'd lived apart, 2 different countries. It was complicated to say the least. And the first conversation they had about their son was in the mediation after the court had finished. And then it was about working out how they could be parents within the framework of the agreements the court had made. But that helped them be a family of a new nature coming out the system. If again, coming back to that peace-making piece, that if you leave the conflict to just sort of untrammeled, go through the family, coming out the court, where is everybody at that point?
Yeah, but again, it just highlights that where that child was for 5 years.
Oh, absolutely.
Professor, do you want to
I'm coming from the outside of the Irish system, and I don't know much about the Irish system. I know that it's adversarial. However, if we are looking comparative law, and I do that in criminal procedure, exactly today we don't have pure adversarial systems anymore and pure inquisitorial systems, and we are somewhere in the mixture, and depends, where, how much we have come close to each other, but and that's why I don't see that we have to stick, and the adversarial system. And if we see that something works, that should be integrated into the system and should be thought about that. Of course, inquisitorial systems were much more open towards adversarial systems, so they integrated a lot of adversarial elements into inquisitorial elements. But if you're looking especially in Canada, then you can see, because they have Quebec and they really integrate lots of things together. And actually at the end, you might get a better product. So it's worth looking at that.
Yeah. Okay, I've been delighted. There's been a number of questions come forward too, so I'm just going to put them out here. We've got about 10 minutes or slightly less than 10 minutes on this, so I just want to put it out there first. In relation to, and we've sort of touched on this, coming from one family report, significant barriers ensuring children's voices are heard in private law due to time delays, costs, lack of availability, quality, regulation of assessors. You all have touched on those things. Again, probably what can we do in the reform of the family law justice system to make this a smoother situation for the children? How do we overcome those things? Apart from, or maybe it's only the answers are more resources. Is that the only answer, do you think, Judge?
Well, I suppose really it depends on how you want the voice of the child to be heard before the court. I think the indirect way serves us very well in many cases. Particularly Section 32 reports, where you have the choice of requesting a report that gives you the wishes of the child or the young person's views, and that's a report that can be obtained relatively quickly and relatively inexpensively, but you have to have people who are available to do it, you have to have people who are going to get paid to do it, and you have to have parties before the court that can afford to do it. And that's extremely challenging then for parties who come before the court and they simply can't afford it, or there's not a professional available to do it in a timely manner. The other way then is for judges to meet children and take their views directly. That can work to a certain point, but we would certainly need to be resourced to do that. We would absolutely need to be trained to do that. One of the indications that was set out in the OD decision is that judges should not be experts, or should not hold themselves out as experts in these interviews, and any conclusions that they reach should be based on common sense and their own experience. But certainly I think judges would require significant training and skills training in order to be able to carry that out, or to do that effectively. Where larger...
Do you think, Judge, do you think they'd be open to it?
I certainly think so. Yeah. Judges meet children from time to time. As I say, it's not terribly frequent, but we do it. But I suppose it's something I would be somewhat reluctant to do if there are bigger welfare or best interest questions, particularly if allegations have been made, and whether the allegation is made that the child's views have been somehow influenced to a significant degree by the other party. Any interview or any meeting that I would have with the child, I wouldn't be properly qualified to make a determination as to whether or not that young person's views have been coloured or not. But I think if we look at what the purpose of the meeting is, then, if the meeting is to give the child or the young person the opportunity to express themselves directly to the court, then that might be a good thing. Okay. Again, where those views and the weight to attach to those views, and where that weight carries significant influence on the judge's decision, then we trespass into that meeting perhaps having an evidential basis, and that's where it runs into difficulty. Okay. So I think certainly what would be most ideal would be the most qualified person being available at a timely manner and in a low-cost way to be able to provide the assistance to the court that the courts need. Just with the hands up, even would the panel be agreed that it's something that the state should cover that cost? Is that a fair thing? Matters of policy, or not a matter that okay, I'll leave it at that. But again, at a low cost availability to everybody is what we want to make sure it's accessible from that point of view. Well, it's the accessibility to it. Yeah. Okay. So again, let me just give another question here. It's that idea of the authentic voice. Have we got professionals that can look at and hear from children
and make a decision that way? Is there something we can lead out there on? The authentic voice of a child, is it the professionals that we put that course to, except they come forward with the views of the child, through whether it's a GAL or child voice experts? Do they come forward to the judge? Is that the best way to do it? Is there any way we can improve that system? I'm just trying to figure out as we build a new system.
Okay, well, I suppose if it's part of proceedings, then they would have to be able to come to the judge to deal with that. I think the case that Catherine referred to earlier on also mentioned in passing the access of the parties, the parents, to those reports and to the outcomes of those reports and to the views of the young people or the children. And I thought it was interesting in one of the speakers earlier this afternoon who noted that the children wanted to be able to speak in confidence, but there's that tension between being able to speak freely in a confidential way and the parties, who are the parents to the case, being entitled to know what information it is that the judge is being given to rely upon. So there are various tensions that have to be balanced, and they have to be balanced on a case-by-case basis.
I mean, just speaking from, I mean, in terms of family mediation, we do have a child-inclusive policy and procedure where children do come in and are listened to, and there are two basic models. One that we practice here, which is where the mediator meets with the parents, meets with the children, and then meets with the parents again, and it's looking at the wishes and needs of the children, and including that as part of the ethic of good conflict resolution practice, that everybody should have a voice in the resolution or agreement that is being made. So that's certainly part of what we do. The other model is an interesting one. It's a lot of people would have know Jennifer McIntosh from Australia. She would really be one of the top proponents of this, where you actually have a child consultant who meets with the children. So they come into the mediation process, the mediator's there with the parents, the child consultant then meets with the children and brings back an assessment and feedback, and the mediator's role is to stay in role and work with how the parents hear that, how they can be helped to take on board what the child consultant has said, and so on. Now, what is interesting about that, if you purely look at family mediation, then you can look at each model and you can say, okay, this is pros and cons and pros and cons. But where we look at our system, and this is something that comes up in the district court where we have offices, particularly in Dublin, in Dolphin House, that the family mediation there may see the child, but we're not designated child experts under the voice of the child, and neither should we be, because we're not experts. But the mediation settlement then goes into the court with a piece saying that the children have been met and this is the agreements and so on. But yet there's a question that the judge then may need to, as part of the voice of the child, have a report that means all that work done is less complete. So is there an argument, and this is an open question for us and much discussed, is there an argument that Jen McIntosh's model of the child consultant being part of the family mediation process, could that then mean that the mediation settlement could go into the court and be treated as a complete piece of work? Now, that is not a question I can answer. I don't have that background, but it's certainly something that is being discussed, and I know that we haven't got an answer for it yet in terms of how the system, but it's a wrinkle. As we look to
develop a new system,
perhaps
something you're adding another string to that piece of the bow. I think that's crucial. I mean, we've probably got about a minute and a half. Is there any left over that anyone wants to put out there just before we wrap up?
No, but we know that in the world are different systems, no, and to what extent and in which way the children are involved. There are even researches on that, so this is good to look at. I was just preparing for this reading the research that was actually done in Sweden, because in Sweden they are very unsatisfied with the system that they have, and they think that it is backward. Where they have the age of 15 and the children are consulted only if they are above 15. Before that, somebody else is making a decision for them, and and the children are not really very much involved in the whole things, and they are always over somebody else, no, who is, and so on and so on, and then they did interviews with children, and it was interesting in that article for me that the children were actually asking for more direct involvement. And then when we are talking about children, of course we are saying that all children and the views of all children who are capable of forming their opinion and express their opinion has to be taken into consideration. But when we are talking about whether this should be direct or indirect, there we can take into consideration the age of the child. So if we have children that are in the older group, then, you know, to have direct makes sense. If you have a 5-year-old child, then maybe it's more sense not to have direct. So we have to think about all these different things. Yeah.
Okay, I'm going to wrap it up there. I want to say a huge thank you to each and every one of you, to Catherine, Professor Turković, Fiona, and Judge Daly. Thank you so much. I think everybody a round of applause, please. I'm sorry I didn't get a chance to go to all the questions. I apologise for that, but again, I think the conversation was moving along swiftly, so I just thought it was best to let it flow. And just to wrap up, I think from my point of view, there's a number of things that stand out. And I think we did get lots of good ideas, food for thought, as we develop a new, hopefully, child or person-centred family law system that we can draw on. But there's a few things that maybe throughout the day that stood out for me as well, and they were adding to here that Lem spoke this morning about sometimes we have to look into the shadows. And I think asking ourselves, do we create a barrier to doing a better system for our children? Are we, in whatever profession we follow, are we creating a barrier? Are we the peacemakers, or are we otherwise in relation to our children's system in regards to separation and parental conflict? Also, the piece from Barbara that spoke about earlier on, I think it really struck me that, you know, children feel separation as an emotional issue, not a legal one. And if we can keep that in mind, and again, Judge Daly was very clear that the law teaches you to take the emotion out of it. So how do we allow that emotion somewhere in our system and provide the support to the judges to make those decisions? So I think for me, those are the things I'm going to take away. And I don't envy you as the people out there making the decisions on how to create a new system. But again, if the child is at the centre and the people around the children are at the centre, then the system develops itself. And again, that could be a radical idea, but I hope it'll be the right idea, and I look forward to seeing how that turns out in a couple of years' time. Thank you again to everybody that's here, and thank you again for the opportunity to be involved in this. It was a fantastic event. Thank you.